next session on reshaping the future of ADR in India through integration of technology and institutional arbitration. I now invite our speakers on the dais.
Our names are yeah. Oh, how did that attention?
Now we will have a short film on the session. Begin the session, I would like to invite our session chair, Dr. Shardul Shroff, Executive Chairman, Shardul Amalchand Mangaldas and Co., to give his opening remarks and take forward the session, please. Over to you, Dr. Shroff.
At the outset, let me thank CII for organizing this particular session, which is very topical and very apt because in a increasing commercial world, arbitration is one of the center cornerstones of how dispute resolution will get tackled. I have a very illustrious panel uh, which is going to address some of the issues which are unique to how modernization in arbitration will take place in India, as also look at issues in relation to ad hoc arbitration versus institutional arbitration. And that's key in terms of how India will be received in terms of the globalization and assimilation of Indian arbitration proceedings in the world. We had a very poor reputation in the beginning, but I think in the last 15, 20 years, India has significantly gained in the arbitration space. As a sovereign nation, India cannot afford to have its disputes be taken out of India. And this is a recognition which is fairly commonplace when sovereigns look at arbitration as a procedure, because effectively we are getting our disputes resolved by other countries, whereas we have the capability of doing that in India itself. The bar of India, in terms of its legal uh, professionals, is as good as any in the world. And I think the proof of that is that all our members on this panel are Indian in origin, and they are by far the best that are there today across the world. It's my pleasure to introduce Dr. Vishwanathan, who has been the former law secretary in the government of India and more recently the chairperson of an expert committee made by the government of India for reviewing the working of the Arbitration Act. I was privileged to work under him, and I know his amazing mind, the way it functions and the way it assimilates all the facts and gets a proper presentation out. I have then Dr. Lalit Bhasin, who, as I was jocularly mentioning a few moments ago, is like the perennial brook. Both he and Mr. Vishwanathan are some of our seniors who have really done so much for the legal society and the manner in which they have organized law firms in the Society for Indian Law Firms is amazing. I have Dipen Sabharwal, King's Counsel, whose reputation in the arbitration world is enormous. He also heads the India chapter or the India bench or bar, whatever you call it, for the firm White and Case, and is a renowned name in that firm also and across the globe for his arbitration contributions. We have Gaurav Banerjee, who also needs no introduction. He's one of our best arbitration lawyers in India, a very clever and precise mind in the manner in which he presents his arguments, and the depth of his arguments are just amazing when you hear him on a platform. We have Philip Da Costa, partner of Pennington Manches, which is a very good firm as far as litigation and arbitration is known, and we would be privileged to hear him today on ad hoc versus institutional arbitration. And last but not the least, uh, I think she's the only woman on the panel, and she requires the privilege that we associate with women on this platform. Uh, this is Parnika Chaturvedi, who comes from the firm of Quinn Emanuel, which is by far the best litigation firm across the world. They are one of the few firms who turn down transactional work because they could be free of conflicts, and they are only doing litigation so that they are free to take up all litigation without having a client conflict. So that's the panel that we have before us. I would request Dr. Vishwanathan to give his keynote address. Thank you.
Thank you, Shadul, for the kind words of introduction. It's very interesting and very homecoming for me to share my thoughts with all of you. You've given me a task of talking about arbitration. I just remember the song from Love Story where Andy Williams says, "Where do I begin to tell the story of arbitration?" And from 1996, when we introduced this unilateral model law, till today, I've been closely associated with this Arbitration Act. We tried everything and still things don't improve. When I have finished my career and I wound up, then this task came to me where the ministry wanted us to review a committee on the working of the Arbitration Act. When the offer was made, I was reluctant to take it up because at this age and without any backup, how do we go about? But fortunately, had the assistance of all these people. Gaurav Banerjee was there, Chadul Sharif, and a lot of people who assisted me. We did a pro bono work. We never charged anything, and most of the work was online. Now, the task which was entrusted to us was very wide. Before going into the terms of reference, I'll tell you what is the problem with the law reform in our country. because I've been in the law ministry. I've been throughout in law, drafting. I've been in laws, I was in the legal affairs. I've been in the law commission. Then I was in parliament where bills were passed. Then I was with the president where bills were assented. So I know fully how the law travels. The problem of law reform in India is that it's based on doctrinal research. It's not backed by data, empirical data. When I was in the law ministry, law secretary, when we were asked to deal with this problem of arbitration, we had to get data. Most of the evidence which was coming before us was anecdotal. Anecdotal evidence. You don't do research or law reform on the basis of anecdotal evidence. We need hardcore data. We could not get. They say arbitration is a private affair, autonomous. We can't share data. That's okay. But what about PSUs? PSUs are government funded agencies. They had enormous stake in arbitrations. We could not get data. I tried my level best, even cabinet secretary tried his best. They refused to part with data. Parliamentary questions were asked, but data never came. Without data, how do you reform the law? Things have changed now. Let me come back to the terms of reference. It was very wide. Evaluate the existing ecosystem of law, strengths and weaknesses, framework for a model arbitration system of efficient, economical, and which caters to all the users, measures to fast track enforcement of awards, statutory measures to reduce recourse to judicial intervention, and then administrative mechanism to minimize routine challenges to awards by the government agencies, renewed principles for determination of costs of arbitration. Again, sensitive matter, costs of arbitration, including fees of arbitrators, guidelines for arbitral institutions, examine the feasibility of a separate law for domestic and international commercial arbitration, recommend a model arbitration agreement for parties to adopt, and a new legislation in simple, plain language. I've been a draftsman. I've written a book on drafting also. Plain language drafting is very close to everybody's heart. Then how do you do that? Our committee has addressed each one of these issues. I wish all of you should report the report. And we have suggested a roadmap to make India a hub of international arbitration. Not only India will become a hub of international arbitration, we can cater to the global needs. As already Shardul has put in measures, and we have the Bhishma Pitama sitting with this Lalit Bashin, whom I've known for more than 3 decades. He has single-handedly fought for the Indian law firms and other things, and we have now the capacity to go up, and how we can manage. Now, now, how do you do? How does the debate is between institutional and ad hoc arbitration? When we implemented the 1996 Act, the unilateral model law, we didn't have the ecosystem. Ecosystem is required for managing any act of parliament. I had been a chairman of the Insolvency and Bankruptcy Court. The Insolvency and Bankruptcy Court contains a complete ecosystem. There is no other law other than the Income Tax Act and the Excise Act and the Revenue Acts where government has ready data. All the acts of parliament, how do they work in practice? There are no impact analysis, no empirical data, how they function. How do you measure the success or failure of an act? The Insolvency and Bankruptcy Code has a complete ecosystem. And when we introduced this 1996 model law, we didn't have any ecosystem. It is based upon on institutional, based arbitral institutions driven by institutions abroad. We didn't have that. We simply imposed this law. I was, as a joint secretary, I was there as a draftsman. We did nothing in drafting. It was simply imposed, and we just implemented it when we repealed the 1940 Act. As a result, what has happened? We didn't have the ecosystem. Things started going in a wrong way. Ever since it was enacted in 2001, when I was in Law Commission, the move came for examination of the working of the Act. So we gave the 176th report. The committee, it went before the Parliament. Bill was introduced. Then it was withdrawn. It came back again and again. Things were going on. Then we had so many reports, so many commission reports. Still, nothing is improved. So we thought we should go back to the drawing board and see what has happened. So it's ideally we have to see, we have to have different types of legislation for different type of users. This unilateral model law may be good for international commercial arbitration, but it doesn't cater to the local needs. We need for small time arbitrations, so many things. Then BITs are classed by themselves. We don't, we cannot cater to BIT needs through this international in this arbitration of 1996. Then we also have technology which can give us enormous advantages. In court hearings, normally it is required that all the parties should be present simultaneously at the same point of time. They may be in different places, but the point of time it should be same. But now we have asynchronous mode of communication where people can talk and record their arguments, and then all of them could be brought under a teleimmersion where create a virtual courtroom. So you have lot of technological advancements where we can think ahead, and we are moving ahead. And then we need specialist techno legal utilities, legal startups, which is becoming a big investment thing in Western countries. And we even arbitrations, ad hoc arbitrations can migrate to these technology savvy virtual courtrooms, which has better efficiencies. I would only request all of you to go through a report and take cues from that. How do you take it forward? I'm very sure we can have digital platforms where we can cater to other jurisdictions, not necessarily to India, and we can also have arbitrations doing abroad. Way back in 2003, when we had been drafting the Special Economic Zones Act, I was the law secretary, Arun Jaitley was the law minister. We had special provisions, international financial centers. Now it's coming up in a big way in Gujarat. Then we have a special dispensation for insurance, banking, and other things. I had suggested to with Jetli we should think of something for arbitration. You have special economic zones where you can do arbitrations. People can come arbitrate and go away. And he was he smilingly told, we have to take Lalit Bashir on board. He should not think for foreign lawyers should not be brought from the back door. He said, you keep it. It's a good idea. Let us see. But I went on pushing this forward. You can think of it. You don't have to amend the law. There is always provision under the Special Economic Zones Act to take care of this side of a situation. Gujarat is showing the way. So you have enormous opportunities. Youngsters are here. You can take it forward. And I am amazed at that the legal capacity of our youngsters in various fields. And I will like to interact with you and share many of our thoughts. I request you to go through my report, and I'm very thankful for CII to invited me to for sharing my thoughts. Thank you very much.
So thank you so much for your opening remarks. Uh, as a process, I intend to ask questions to the panel, and if time permits, we will have a Q&A at the end of each one's responses to the question. So I'll start with Mr. Philip DiCosta. He is a partner at Pennington's in UK, and I would seek some response to the question on effectiveness and efficiency between the institutional arbitration framework and ad hoc arbitration framework, as to what are the advantages and disadvantages of both these systems in a country like India. Can both coexist? And how do you see the role of institutional arbitration uh, changing the manner in which arbitration from India is received globally in terms of its recognition and its due respect? Over to you, Philip.
Good afternoon, everyone. Thank you, Shardul, Dr. Vishwanathan, Dr. Basim, uh, esteemed panelists. So it's a great pleasure to be here at the CII conference. It's been an excellent couple of days. So just to put that into context, I'm sure this doesn't need to be repeated, but in case there are any non-arbitrators here, institution arbitration is where you use the rules of an institution, be it CIAC, LCIA, MCIA, the IIAC, any other body, to determine the rules by which the arbitration is going to be governed, procedure of the arbitration, and to effectively give you those guidelines, give you the remedies through the process where you have issues. You refer back to that institution. The institution will help you in terms of appointing the arbitrators, going through that process to a final award. An ad hoc arbitration, by contrast, is one where the parties have autonomy to effectively define the process. So they can agree between them. The process we're going to follow in this arbitration is going to be, we will appoint an arbitrator between us, and we will then go through that process. And you can make that as light as you wish. So you can truncate certain aspects of that arbitration, or you can make it as detailed and lengthy as you want. So that's the differences between the two at a high level. In terms of effectiveness, I guess my view would be that the efficiency that you get from an institutional arbitration is that you have a set of rules that have been thought through. They've been determined, defined, published. And then everyone knows these are the rules by which this arbitration is going to play out. And then you follow through those rules. You have the ability to seek guidance, to get guidance, to determine how the process, where you have issues, should be determined, and you go through the final award. That can be quite efficient. When we talk about the efficiency of ad hoc arbitration, because that is a more informal process, you might be able to do away with some of those layers of steps that the institution requires you to take. You're effectively taking a prescribed set of rules and procedures. So if I give you an example, I can go into a restaurant and I can order a 9-course menu and go through those courses, or I can simply order one dish. I can order a biryani or a khichdi. That's my dish, one course, and we're done. That's a much more efficient, a quick process perhaps than a 9-course process. However, it only works if it's appropriate for the dispute that you're resolving. So sometimes a dispute does need 9 courses. You do need to go through a much more detailed process. If you can truncate proceedings by length of pages, for instance, that will be appropriate for many cases. You might say there's a limit on the number of pages of pleading. There's a limit on the number of rounds or amendments. There's a limit on how we do disclosure. There's a limit on the issues that we will need to disclose to. The process of disclosure, we can agree, can be light and goes to specific issues and key documents provided by an institution, or it can be open-ended, broad, and wide-ranging. So in terms of advantages and disadvantages, ad hoc arbitration has the advantage to be able to modify and cater to smaller cases or to particular types of cases where you can truncate that procedure. The same goes for cross-examination of witnesses. Again, you can guillotine the time that the advocates are going to take over the witnesses and say, this is what we're going to agree. So it's not going to be as detailed a forensic examination as perhaps you might otherwise have in a court process or in a full-blown arbitration. Similarly, in terms of remedies, one can look at trying to limit the remedies that one goes to. In terms of, let's say, changes globally, I would say what we are seeing is institutions providing different sets of rules and different procedures for different sizes of arbitration. So again, in a country as large as India with many levels of dispute, I think what would be good is to see rules that cater for different disputes and that you choose the appropriate menu to suit your palate.
Thank you, Philip. I'll now turn to Dipen for asking him the question as to how do you see the role of artificial intelligence in both domestic and international arbitration? What role can AI play in procedural hearings, constitution of an arbitration tribunal, providing an interpretive consulting tool, facilitating natural language processing, enabling research, comparing, summarizing, and extracting insights from large volume of text, images, and data, how you can streamline text drafting, legal research, customization, and facilitate pleadings, responses, and awards. Over to you, Dipen.
Thank you, Dr. Shroff. So, artificial intelligence is obviously the hottest topic in the world right now. You can't go to a conference without hearing about it. You can't read a newspaper without thinking about it. And the short answer to the question is that artificial intelligence will have a significant impact in arbitration, much like it would in all other aspects of law. Now, I'm careful of the admonition that Dr. Vishwanathan just gave at the podium, where he said that subjective opinions are easy, we need data. And it reminded me of what Narayan Murthy used to say, that in God we trust, everyone else must bring data to back up their opinion. So I think it's only fair that I share some data. The International Bar Association has been conducting a survey of its technology committee for a number of years. And as recently as 3 years ago, the majority of its members had no experience of using AI and had no intention of AI tools. In this latest edition, the vast majority of their members, 74%, said that they expect to be using artificial intelligence in their day-to-day work in 2024. So that has been a massive transformation that has happened in front of us in the last 3 years. How is this going to play out in arbitration? I think it's going to play out in three very immediate ways where there's low hanging fruit in arbitration that AI can help tremendously with. The first is with the transcription and a live note of proceedings. And that is a huge, huge opportunity for arbitrations in India in particular, because globally having a fully automated live transcript has been the norm for many years. In India, that is very much the exception than the norm. AI is going to reduce the cost and make it readily accessible. I think the taking of evidence, the recording of evidence will really, really be shortened and become more efficient as a result of that. So that's the biggest opportunity I see in Indian arbitration. Second is simultaneous translation. You have cross-border disputes. You may have a Japanese party. You may have a Korean party. You have witnesses who are comfortable in their native language rather than English. You always have the issue of sequential translation, which slows the process down. You can actually have real-time simultaneous translation, which can make a huge difference. And the third impact is document production, disclosure, discovery, humongous number of documents in large complex arbitrations. The searches of those documents, the production of those documents can really be expedited through the use of AI. So those are three low-hanging fruit and immediate opportunities. Now, I think in the question that Dr. Shroff asked me, there are a number of other things that AI can also do. AI can help you with the drafting of pleadings. AI can help you with the analysis of case law. AI can help you in the production of legal submissions and even perhaps even the drafting of awards and judgments. For my part, I am far more cautious about those use cases with the technology that we have today. I think we have to walk before we can run. And I think there is enough low hanging fruit before we make that leap to the next stage. I want to end with a warning as well. And the warning is this, that AI risks being this bright, new, shiny toy that distracts all of us, especially in the context of Indian arbitration, where there is still a lot of hard work which needs to be done. We were just hearing about institutional arbitration. We were hearing from Dr. Vishwanathan about the reform to the 96 Act and the other reforms that are taking place in Indian institutional arbitration. There is still a lot of hard work which needs to be done there to make arbitration successful in India. AI can definitely be a tool that helps with it, but I don't think it's going to be a magical panacea which is going to solve everything. And we should resist that idea.
Thank you, Dipen, for that note of caution. And thank you for your astute observations. I now turn to Dr. Basin, the president of the Society of Indian Legal Firms. And I would like to ask Dr. Basin as to the cooperation agreement between CII and the Society of Indian Legal Firms, because I understand that the virtual arbitration center which the CII is setting up is going to be housed in the SIF building in New Delhi. Could you, in your words, let us know how the legal community and the business community could advantageously use this CII Center of Arbitration for quality resolution of disputes across various spectrum of disputes ranging from summary or what is known as the sniff arbitrations, online dispute arbitrations on resolutions, consumer protection, product liability, and also complex commercial disputes. What measures will the SILF and CII take to register themselves as arbitral tribunals and also as mediation forums for recording of mediated settlements? Over to you, sir.
Still, a lawyer used to stand before the court and make my submissions. So I feel very comfortable while addressing this august audience while standing. Dr. Shardul Shroff, it's indeed a privilege to be a part of this panel here. Mr. Vishwanathan, Senior Counsel Mr. Gaurav Banerjee, and all the other co-panelists, CII representative Tanushri and Shalini, everyone here. I was very impressed, you see, with this theme of the event of CII, co-creating the future responsibly. Now, co-creating, that is the gist of that is the theme of this event. And that is where we need cooperation between business and law. So the step taken by the Society of Indian Law Firms as representing nearly 150 law firms of the country, I think it's a step in the right direction. Then when we decided to have a partnership, you see, partnership not in the sense of profit sharing, partnership in the sense of collaborating in the interest of administration of justice, you see, to join hands and set up a center of excellence for dispute solutions. Now, dispute solutions can be in the form of arbitration, it can be in the form of mediation, and various other forms, you see. That is why, but the initiative actually came from Dr. Shardul Shroff, who is like a champion for promoting the cause of dispute resolution and has helped us a lot along with my colleagues here, Tejas Karia and Ajay Thomas. So the idea is to set up this institute, to make it work, whether it will be virtual or it will be physical, that will all depend upon what CII would like to decide. But the cooperation of SILP will be always forthcoming. Recently, again as a measure of cooperation between business and law, the Arbitration Bar of India has been set up under the presidentship of Mr. Gaurav Banerjee here. I think that is also a step in the right direction, that we are collaborating, we are helping, you see, the business community. Because otherwise, it is a lip service that we are doing, you see, to the cause of dispute solutions. We have 5 crore cases pending, therefore, litigation is not the answer. Arbitration is supposed to be the alternate dispute resolution mechanism. But in order to make it effective, and I'm very sad to say that so far it has not been very effective. In order to make it effective, we need collaborations, you see. And that is where CII, as a model chamber of commerce, has taken this initiative to set up, you see, this excellent center of excellence so far as dispute solutions is concerned. In India, why arbitration has failed is because we don't have good institutions of arbitration, of dispute resolutions. The legal fraternity is there to help, but it is the disputants, you see, the parties which want to have, you see, confidence in the body which is administering arbitration. Ad hoc arbitration will not work. It is monopolized by our judges, you see, retired judges and even lawyers and all that. It has to be broad based. So that will be the function of this institution, which will help, you see, the corporates to have their disputes decided in India and not, you see, to go to Singapore or Dubai or other institutions. And that is what the Prime Minister said, why India can't be hub of arbitration, rightly so. And that is where even the foreign lawyers, you see, who can, there is no bar in their coming to do arbitration matters. The Supreme Court has permitted that. That would also help in creating and generating, you see, sense of dispute resolution and making India also a center, a seat of arbitration rather than people going outside. So we welcome foreign lawyers also to come because there is no bar. That is the way I hope and I wish that this center will progress, of course, under the overall guidance of Dr. Shardul Shroff and with the CII leadership taking this hand. Thank you very much. Thank
Thank you, Dr. Basin, for your visionary approach as to how CII and its arbitration center can really kick off resolutions as far as the business community is concerned and the legal community. I now turn to Ms. Parnika Chaturvedi, who is a partner of Win Emmanuel, and I ask her the question of when using technology for quick, speedy, and low-cost arbitration, what safeguards should be embedded in the systems and technology and application software? Is it possible to secure such safeguards in ad hoc arbitration? What measures, in your perspective, have been introduced for cybersecurity in virtual, domestic, or international arbitration? What processes needs to be carefully managed in relation to data management of a virtual arbitration center? How would cloud computing without any physical servers enable a seat of arbitration? And how should the laws of the contract, laws of the procedure of arbitration, and laws for the enforcement be articulated in ether or cloud computing by contractual prescriptive solutions or rules of virtual arbitration? Over to you, Padma.
Thank you, Dr. Shroff. It's a lot of, I'll take each of the topics separately. There are quite a few compounded questions in that. So I'll first start off with generally about cybersecurity and data protection. They're both dominating topics of conversation in arbitration generally, and I think globally across businesses, these two things have become very popular because there's sensitivities around data which are finally being understood and realized. So, in arbitration, this becomes very important, and whether it's low cost, high value, complex, because for each party participating in the procedure, it is a matter of their sensitive data. that is one of the reasons why they've gone for arbitration, because they have confidentiality. It's not data that would be put in for the court where everyone can see it, hear about it. It's data that they want to protect. So it's one of those things where all stakeholders in an arbitration, whether it's the institutions, it's the arbitrators, it's the law firms, the lawyers, everyone plays a role. And while there are guidelines for lawyers and law firms, they're the international, the IBA guidelines, there's nothing for arbitrators. Institutions have got these generic sentences in their rules which say you should take measures to protect the security of data. But where does that leave the actual stakeholders, the ones who really matter, the parties to this arbitration? And what we see happening is people are becoming more and more conscious of this, and steps are being taken at the start of an arbitration, right at the beginning, where discussions are happening on what can be done. So it could be something as simple as secure files are being created, secure platforms are being used, or as Dipen was mentioning, for instance, when you're doing transcription. So these institutions themselves are providing services where you can securely store data, which can be accessed by everyone. So something as simple as that can protect the security of this data. And it's not a hypothetical scenario. I'll give you an example, and this was a very high profile. There was a arbitration panel set up, a PCA panel, in relation to a dispute, maritime dispute between China and Philippines. All the data was hacked, and the system was down for a week. They couldn't access it, and you're talking about two countries here. So if they can't protect their data, with all of this in place, businesses really need to be thinking about it. Um, Moving on to the next question that Shardul posed in terms of how do you manage this between institution and ad hoc arbitrations? And I think it's a three-step process. You start with training. It needs to be training of everyone from your tribunal members, your law firms, staff, institutions. Then you make technology easily accessible, and this is happening where people can reach out and get technology to secure that data. And the third is you make this organizational, is how I'll put it, because it's very difficult for individuals to go and ensure that their data is secure. But if you make it into if I can call it a business, it's easier. You know where to go, you know who to get in touch with, and you know how to protect that. On cloud computing and contracts, and how do you look at that, and how do you look at virtual sort of arbitrations that are happening? What happens with the seat? What happens with enforcement? Um, a lot of the e-contracts that were formed at one point, there was a lot of discussion on where the contract was being formed, what was the dispute resolution provision, where would you have your seat. And it's the most sort of, you hear it all the time, but you forget it. You have to be clear in your contract what you want to do, where you want your seat to be, where you want the arbitration to take place. And it doesn't mean the arbitration, everyone has to be present at that place. If your seat of arbitration, let's say, is Delhi, it doesn't mean that everyone has to be physically in Delhi. You can have a virtual arbitration with people at different places. Your seat remains Delhi because that's what you have chosen. And people realized this a lot, how easy it was to actually do it with the pandemic happening and all arbitrations taking place virtually during that period. It didn't change the seat. And that's the point why you pick the seat. You can have it. It's not the place of arbitration. It's not the physical place where the arbitration needs to take place. Thank you.
So much, Parnika, for summarizing all that extremely beautifully. I now turn to our last speaker, and certainly not the least speaker. I have posed a complex question to him, and let me sort of articulate it with you. India is obviously a leading services community and a country with a reputation for its technology advancements and innovations and unicorns. In the context of reshaping the dispute resolution, how does one look at India emerging as a global virtual destination for dispute resolution and for virtual managed reconciliation and mediation proceedings, which are speedy, accurate, qualitative, and low cost, so as to create a world beating competitive advantage over all other nations? How can India create a virtual international court by cloud computing and courts in cyberspace, where the terrestrial connect can be conferred on a local body within an enclave or a special economic zone or dispute resolution zone, having the trappings of a court but outside the judicial system of the Constitution of India in territories like, for example, the gift city or any special economic zone or any declared dispute resolution zone or enclave manned by globally selected judges, international judges, or quality dispute resolution professionals. There are lots of sub elements in this question, and I trust Gaurav to address all of them.
Thank you, Dr. Shroff. This seems to be by far the most difficult question that has been posed to anybody on the panel, as always. Uh, you know, um, uh, as an arbitration lawyer and now president of the Arbitration Bar of India, you go to these conferences and it's the same topic about how India is to become an arbitration hub. But for the first time, I find a very interesting question, and an interesting question in the background of what Dr. Bhasin has said and what Deepen and Parnika have highlighted about our strength. So, our strength as a nation is technology. And this concept of a virtual platform for arbitration, or maybe even a virtual court, is something which is certainly unusual, novel, and very interesting. And there are, according to me, a number of benefits that can flow from this. And I think uh, I'm trying to analyze Dr. Shroff's question carefully, but just the fact that you have a virtual platform eliminates so many problems of cost. Lawyers are busy, they don't want to travel, clients are all over the place. There is efficiency. uh, Other than cost, there is efficiency. You have a platform. That platform will store all your material in the cloud. You can use, as Deepen says, artificial intelligence to have a situation where document discovery can go on. And this is not in the air, because from what I was talking to Dr. Shroff earlier, this is something like the platform which I believe they have given over to Sylph. So I would be very interested in seeing how that works. So to answer the question, I think this is an idea which certainly needs to be taken up. We have a lot of institutions in India. We have IIAC, MCIA, we have some foreign institutions like LCIA, SIAC, etc. But we have never really had a virtual platform, and there is no reason one should not promote this. And Now, specifically, some areas which have been asked and my responses. Before I come to the SEZ issue, how do we implement this? Before that, or an international court, I'll just make one side comment. Uh, Deepen mentioned transcription. Some of you may have experienced arbitration internationally, some of you may not. So, transcription earlier was very, very expensive. So, the situation was you flew in people from Singapore. There was that lady, she would sit, she would type on some fancy computer, some fancy typewriter, and it would be lakhs and lakhs. Today, India has developed homegrown technology. There's a company called Teres, which works in the Supreme Court. There are two or three other platforms, two or three other service providers in industry who have, through artificial intelligence, slashed the cost by 90%. So when you speak, they have an algorithm and it automatically or translates into text, and it is much easier and much less expensive. So our strength of technology with all this means theoretically, practically, it is now possible. Now, what is the problem? Because all these things, obviously, it is innovative. Industry must be willing to accept such an innovation. Our institutions, as of now, are not very credible. So, whatever we say here, we go off to Singapore, we go off to London, we go off to Dubai. If CII and SILF put up a credible platform or an institution which is virtual, which is cost effective, then I don't see any technical legal hitch at all. I mean, uh, talking about the committee, Dr. Vishwanathan, the Vishwanathan committee report, of which Dr. Shroff was a party, I was also a party, Tejas, etc., were all there. We have tried to plug in the legal gaps. So, one aspect which is problematic is there is no recognition of techno legal facilities up to now. So, one recommendation is in section 6A, 6B. You should read you might read the report, that there should be legal legislative recognition of techno legal facilities like transcription, etc., etc. So, there are some small legislative gaps which can be filled in. Infrastructure wise, virtual will replace brick and mortar. The third element will be human capital, which we are trying to provide through Arbitration Bar of India, dedicate team of lawyers, training of arbitrators and such. So I don't find a problem. The next step, which is the international court, is possibly uh, rather a greater leap. Uh, in both these situations, and the third issue is, what about something like Gift City, whether we have a virtual setup there outside our legal system? I'm not sure we can fully go outside our legal system. Our Article 226 will still apply, Constitution of India will still apply. We have this example in Dubai with the DIFC and the local litigation. That is an idea which is certainly to be considered. But this virtual aspect is what is intrigued me today. And I feel if we push this, we can even possibly achieve even an international court, obviously not in the immediate future. What is the downside to it? With a virtual institution like what is being set up, which SILF is doing, or with a virtual court, there are issues of location of the seat and maybe issues of enforceability. I don't think arbitration awards there should be much of a problem. You can even set it up in an SEZ. You can, under the New York Convention, say it's a foreign award. You can give it all the protections. You can have enforcement. To have a court with the judgment of a court being enforced internationally, we are not party to the Hague Convention as yet. That may be slightly more difficult. But I think all these are lawyer-like problems which I'm floating. The real point is, if you have a credible institution, which is a virtual institution, it is a better solution, according to me, than a bricks and mortar institution.
Thank you so much, Gaurav. As expected, you have rightly tackled what or could arise in the context of virtual arbitration processes. Uh, After having asked all of them one question which addresses modern issues in dispute resolution, we will take one or two questions from the audience and then wrap up this session. So if you have any question which is cognate to what has been talked today, then by all means raise it, and you can also ask us which member of the panel should answer that question. So I leave it to, yeah. Just introduce your name and your question. And keep the question precise, please.
Yeah. Good afternoon, everyone. Thank you very much. My name is Shekhar Joshi. I am from Mumbai. Basically, I'm going through arbitration proceeding with one of the PSU in our company from last 4 years. It's a very painful activity. Now is a vacation time, so I'm working with a Japanese company, and Japs are getting fed up with all the arbitrations the way we are functioning. Somehow the other way, it is getting postponed, and we are really keen to know how this vacation will be taken care of in this, and how the uh, High Court will be there involved or not involved, or which are the court judiciary will be involved, not involved. Because the things we are facing right now is really painful, really sad to see, because it is a PSU and we have a global contract with the PSU, and that is why we have to go with this. But it's very unfortunate to see such things when other our say headquarters from Tokyo or Singapore, they say what is going on. This is very
So
sad.
what is your question?
So I wanted to know whether this vacation time and all these things which will be applicable for the CII things.
I don't think that's really virtual arbitration center, but I can tell you one thing, that because it is without situs, it can take place in ether or cyberspace. The vacation doesn't matter. If you're really interested in, say, a 2 hour sitting or a 5 hour sitting, one can always take out one day in a whole vacation and deal with it. So it's a question of attitude of the arbitrators rather than the possibility of doing it. In a virtual process, you can do anything. Years ago, I had contemplated, when the first virtual reality had come out with the kind of frames or goggles, that you can do an arbitration and decide how you want to, because it's virtual reality. So the whole concept of converting arbitration into a spatial experience rather than a physical experience makes everything possible. It's the attitude of the arbitrators and the attitude of the lawyers which needs to change, for which we cannot have prescription. We can't tell a lawyer, please don't go on a vacation, or we can't tell a arbitrator, don't go on vacation. But we have to facilitate the conduct of arbitration without interrupting somebody's holiday. And that can always be done by requesting for one day out of, say, 10 days, if they are conscionable people. And therefore, it again boils down to, how does one select the arbitrators? What kind of empathy does that arbitrator carry? Does he carry that sense of urgency himself, that commercial disputes cannot go on forever? That's the answer. It's tragic. It's sad. Yeah, if you can ask, yes, mention your name and then state your question. It is a problem. It is just too much.
Hello, thank you very much for excellent knowledge which you people are really providing to us. My name is Murli Prasad from IIT Kanpur, and my
Speak a
simple
little
question
into the mic, please. Can't hear you clearly.
is it fine? My name is Murli Prasad from IIT Kanpur. What I'm thinking while I'm listening to the panel, uh, at village level, there are arbitrary kind of resolution if there are any conflicts, both economic and non-economic, specifically property related disputes. And there is a elderly people in the village system, and whatever the disputes they have, and if the elderly person says, and they take the information, because in the village the information really quickly generated, and then it is accurate, and based on that, elderly person uh, give a kind of um, resolution, and it is completely trust based. And from that to bringing a kind of national, international technology, and simply it is a kind of human to human. If it is a money is concerned, whether there is a something it is going to you or coming to me, it can be sorted out later. But what about the non-economic related disputes? Is it possible to bring that also into the domain of ad hoc and institutional arbitration resolution. Thank you very much.
I think the answer lies in getting that technology across to the village. The success of really resolving disputes is because it's a close community. Sorry? Yeah, I'll just finish it. Is success of the community and the enforcement by the community. The fact that you have the elders looking at the question and it pertains to the community, and that there is trust in the elders to really pass an appropriate order or judgment or whatever you call it. It's a panchayat decision. And then it is binding on people because they have the strongest ability to excommunicate somebody who's not falling in line. That logic can't be extended when there are cases like what the gentleman mentioned between countries or between nations where languages are different, customs are different, processes are different. The concept of creating a virtual arbitration try and minimize the disruption because of local factors. But the issue that you raised, that why can't we take this down to the village? Answer is yes, we can take it wherever. Because it's virtual, it can go everywhere. And so there is nothing that is not possible in a virtual system. You can take it to a village, you can take it global, you can take it domestic. It's all possible. So you want to say something?
We handle your issue in a report because for
You just speak in the mic.
small claims arbitration, we have dealt with separately. We are aware of that. You don't need a unilateral model of that. But as Shardul said, a virtual mode is now in the villages. Everybody has a cell phone, everybody has a Gmeet and other things. But that is not an issue. But the issues which you said requires a separate treatment. We have handled that in our report. Please read our report.
Thank you, sir. Philip, you wanted to say something?
Hi, yeah, Shadab. Just to address that question first of all, I think that's a great example because there's a universe of ADR, and you can have independent determination. You can go to an individual who is an elder, an expert, and ask them to determine your dispute, and that can be also in a commercial context. So there is a space for that, and particularly in a country as large as India, there are going to be many different types of dispute where that is a piece of the solution, I think, and it should be something that is explored and taken forward using the processes that we have that work. Just taking the other example that the gentleman mentioned about the 4-year arbitration, uh, we are talking about the theme of this conference is co-creating the future responsibly. This is an existing dispute. I think we all have a responsibility, but whether it's the arbitrator who is appointed and is presiding over a dispute, the advisors, the advocates, the legal advisors, or the parties themselves to arbitrate responsibly. And there is here, it's a question of simply saying that culture is about adjournment or about length of time. It's about creating the right results, in your case, acting responsibly, and trying to bring uh, a resolution to disputes in an effective and efficient manner. That's something each of us can effect in the disputes in which we're involved.
Thank you so much, Philip. One more question. Okay, Vinodji, that's the last question we are taking. Make the question precise, sir.
I'll be very precise, Shardulji. My name is Vinod Jain. I'm a chartered accountant. We primarily help people representing them before arbitrators. Getting a good arbitrator is the biggest issue. When you define in an agreement how to select an arbitrator, that is the most difficult. Where to find good arbitrators, and whether there is anywhere you can keep track of whether such person has been good or bad is an issue, because time and cost both are huge in arbitration. And we have started telling all of many of our people, don't go for arbitration at all. Courts are better. So that's the reason I thought I'd try.
That is where you need, you see, good arbitral institutions which inspire confidence, you see, in the parties, They decide who will be the arbitrators and all that. Unlike what we have at present, ad hoc arbitration and all that. Therefore, to have good institution, that is the answer to your question.
And just very briefly to supplement that, I fully agree with Mr. Bhasin. The arbitrations should be your first port of call. The other independent resources that are now available to you. So there are a couple of two international research agencies. One is Global Arbitration Review. The other one is called Arbitration Research Tool, ART, and which is run by an organization called Jus Mundi. And essentially, arbitrators around the world can sign up with their database. The number of arbitrations that they have seated in, peer reviews are all available. So those are two independent research tools available to any user to do their own due diligence, independent of reliance on institutions, which Mr.
But
Bhasin is
Deepan,
suggesting.
it's not, we don't have that for domestic arbitration at all. So that's a completely different kettle of fish. And I entirely agree with my friend there that this is actually the Achilles heel of arbitration, how to get the right arbitrator. And Dr. Bhasin's answer is one. We at the Arbitration Bar of India are trying to have some training programs, some arbitrators who are not retired judges, but it's a work in progress. I think the answer is you have to have a credible institution to appoint. Cannot do it ad hoc.
Yeah, so just summarizing what both Dipen and Gaurav mentioned, the requirement which perhaps SILF and CII can undertake is to maintain a roster of arbitrators because they will be of the bar arbitration bar. There has to be a feedback from disputants at how the arbitrator conducted the proceedings, whether he did it fairly, whether he did it abruptly, whether he gave his award in time. And that report effectively, as was mentioned, this is what GAR does, is effectively the credibility report of arbitrators who have functioned. And if that is available to members of the public and disputants, then you can predict in advance which are the good arbitrators and which are the arbitrators to avoid. That is the summary of what both of them have said, and this is something which we can implement.
And arbitrators should not just be judges or lawyers. I think they should include chartered accountants, technocrats, engineers, architects, and all those. We have to broad base that in order to make, you see, arbitration successful.
So thank you all, members of the audience. It's been a exhilarating session today. And I think in the course of discussions, both Gaurav and Dr. Bhasin have mentioned that a virtual arbitration center is being set up by CII. I've had the privilege of giving them the entire software, and we will be shortly setting that up. The SILF building, which is been very, graciously given by Dr. Bhasin and the Society of Indian Legal Firms, will house this whole center in the sense of one physical location in India before we can possibly shift it globally. And because it is virtual, it can be replicated in all cities. You can have mobile equipment doing this process, and it has enormous possibilities. As Gaurav clearly mentioned, we will need to have an association with the arbitral bar council for getting the right people to judge these disputes, because the credibility of any institution is dependent on how the arbitrators conduct themselves and how the records and the process is kept pristine and good. So we are all hoping for the best, and that is something which we have great pride in telling all of you. Thank you so much for this.
Thank you, speakers, for that very interesting discussion. I now request Dr. Shroff to hand over a token of appreciation from CII to our esteemed panelists. Dr. T.K. Vishwanathan. Dr. Lalit Bhasin. Mr. Dipen Sabharwal. Ms. Parnika Chaturvedi. Mr. Gaurav Banerjee. And Mr. Philip DeCosta. I now request Ms. Chaturvedi to kindly give a token of appreciation to Dr. Shroff. Request all the speakers to please stand for a photo opportunity. With that, we close this session. I invite all the delegates to join us for lunch.